So it is my pleasure today to introduce our speakers, Matt Parker and Sam Lillard. Matt is going to speak first. He's an associate in the firm's Columbus office, that being Fisher and Phillips. His practice involves the representation of employers in various types of employment litigation. He also counsels employers regarding various day-to-day employment policies and practices. While in law school, Matthew was a competitions editor for the Cardozo Moot Court Honor Society, and during his time on moot court, he participated in several competitions and earned the third place Oral Advocate Award in the Tulane Sports Law Moot Court Competition. That's not easy to say.
It's a word jumble.
Upon graduating from law school, Matthew was inducted into the Order of the Barristers, a National Honor Society which recognizes individuals who have excelled at advocacy and service at their respective law schools. Prior to joining Fisher and Phillips, Matthew was an associate of boutique employment law firm in New York City where he litigated individual and class collective action claims nationwide. So please welcome Matt.
Good morning. So I'm here to talk about the Fair Labor Standards Act, and Sam has another topic, and I think we'll be able to answer your questions in that regard, but we were a little late getting in because we couldn't get into the parking garage. So if you have any questions about accessing it, we're certainly not the ones to bring those to. Show of hands, the FLSA on everyone's radar today, or people just now getting acquainted with it? Okay, so by now, you know, the FLSA, just by way of background, it's a Great Depression era law dating back to the 30s, and its original purpose was to essentially increase the working standards for people that were putting in hard days of labor and to make sure that they were receiving fair wages for a fair day's work. And that was essentially what FDR had said when he had signed the law, signed the bill into law, was saying that this is putting an end to starvation wages and intolerable hours and providing a fair day's pay for a fair day's work. And in the almost 80 years that it's been around, the FLSA has largely remained in its original form. There have been updates over the years. The most recent occurred in 2004, which is similar to the update that is occurring this time around to the salary basis test. But today, the FLSA still remains strong as the primary federal law that regulates the payments of wages. In addition to the FLSA, some states have their own wage and hour laws. Other states do not, and they simply track the FLSA. And those states that do have their own wage and hour laws generally will be a bit more restrictive, will provide more rights to employees. Some might provide different forms of damages. Some might even provide employees or former employees a longer amount of time within which they can bring lawsuits or bring issues that relate to wages and hours to their employer to handle. So as I mentioned, the last updates were in 2004, and those were also to the white-collar exemptions. Now, the FLSA has essentially four main things that it regulates. The first being minimum wages. The second is premium pay for work over 40 hours in a given work week. The third is very stringent record-keeping requirements of employers, placing the burden on employers to accurately track the working hours of their employees. And the big surprise to most people is that those record-keeping requirements apply to your employees whether they're exempt or non-exempt. So whether you pay them on an hourly or some other basis that's tied to their working time, or whether someone is paid a certain salary that's the expectations that it will cover all of their hours worked. And that's an important thing that a lot of employers sometimes forget about, and which can put them in hot water down the road if an employee challenges their exempt status and the employer does not have any accurate records of the amount of time that they spent working. And finally, the last thing is it puts limitations on labor for individuals under the age of 18. The FLSA is enforced by the Department of Labor, and it also provides for private citizens to enforce its provisions on either an individual or even a collective basis. And the main question is that a lot of people think about, well, does it apply to me? I'm not that big, or I'm a mid-sized employer. And generally, the FLSA is going to apply to nearly all employers. It's a very broad definition of who it applies to. Essentially says that the FLSA is going to apply to employers and employees that are engaged in commerce. And it does have a limitation that you have to at least have a volume of business that is $500,000 or more. And there are many, with the exception of maybe very small employers, that are not going to fit into those requirements. So a little bit of background on these exemption changes. They've been, as it sounds like everyone's kind of familiar that they're coming, they've been in the works for 2 to 3 years. They were originally announced in around 2014, and at that time, President Obama had mandated for the Department of Labor to look at updating the regulations as far as the exemptions were concerned. He was particularly concerned about the salary level threshold, and so charged the Department of Labor to go through the notice and rulemaking process that's required to change the interpretations or change what is actually contained in the regulations implementing the FLSA. In 2015, the Department of Labor published its proposed rules, and then they went through what's called a notice and comment period, which gave the opportunity to anyone that wanted to review the proposed changes to the rules an opportunity to say, hey, we think this is a great change and this is why, or the flip side saying, we think that this change would be detrimental and these are the reasons for it. And so giving all sides an opportunity to have their voice in the implementation of what would become the final rules and to kind of debate with one another about if we're going to change these, what would those changes look like. And then earlier this year, the Department of Labor published its final rules, and those are going to affect almost every employer in some way, and they go into effect as of December 1st, 2016. So in terms of what Sam and I have been counseling our clients to do is just first off is just to take notice of the change. There have been some people that we've worked with that have been thinking about this going back to 2014 and have assumed that there were going to be changes taking place and starting to look into different things that they can do to either implement the changes or how they can reorganize their workforce in light of the changes. There are others that it's been on their radar the past few months, knowing that 12/1 deadline is approaching, and although it may be not a surprise to anyone in here, it seems, but there are also some people out there that we've talked to that are surprised that we're not aware of the changes coming up and that now are kind of being pressed by this deadline that is looming just a couple months down the road. The next thing that we've talked to folks about is just beyond just acknowledging the changes, take a step back and determining whether there's any impact on your business itself. And finally, is if there is, which there probably is going to, is start developing an action plan, which could be complex or it could be very simple depending upon your business needs, but certainly getting together the certain action items that you want to take care of and address with your workforce that is potentially impacted by these changes so that you can do so in the coming months before December 1st rolls around. So, when we talk about exemptions, the first real question is, what are they? And basically, if the exemption applies, it's going to mean that you don't have to follow at least some requirement of the FLSA. And in this case, when we talk about the white-collar exemptions, and if it applies to an employee and they're exempt, basically what you're saying is that based on this individual's salary and the type of duties that they perform, they are exempt from the requirement that you pay them overtime for any hours over 40 hours in a given work week. Now, the important things to remember about the exemptions is that they're narrowly applied. And basically what this is going to mean is that the burden of proving that the exemption applies to an employee remains on the employer. And if there's any doubt, if there's any question, if it's 50-50, that doubt will be resolved against the employer. So when you look at whether these exemptions apply, it's important to keep in mind that these will be viewed against the employer and more favorably in terms of whether they apply for the employee. And so the default rule is you always want to start out with the assumption that an individual is non-exempt unless you can determine that they affirmatively meet each of the requirements for the exemption. And we talk to people, this is really a specific, detailed criteria that must be met. And you should really be looking at your employees on an individual by individual basis. You certainly run risk of misclassifying individuals or even whether that's classifying them as exempt or non-exempt if you try to look at them collectively. There's also risks if you just simply look at a job description and assume that the duties that are laid out on a job description are actually what that employee is performing on a day-to-day basis. Also, just generalizations about what employees should be doing or what the employer's expectations are, or even looking to see what other folks in the industry are doing, how they're classifying individuals in these positions. When you take a step back and you're not looking at each individual on an individual basis, in speaking with them or their supervisors about what they're actually doing day in and day out, there is always a risk that those exemptions could be improperly applied. So when we say white-collar exemptions, we're really talking about three main exemptions, and those are the executive, administrative, and professional exemption. There are also a couple other exemptions that will fall into here. There are a number of iterations of the professional exemption. There's also an exemption for computer employees and highly compensated individuals. But the exemptions that will impact, the changes that will impact most employers will occur on the executive, administrative, and professional exemption levels. So just for a very general matter, the requirements for each of these exemptions to apply, there are essentially three main ones, as you can see. The first is that they're paid on a salary basis, which essentially is that they're paid a salary of a fixed amount for your given work week. The second is that what's called the salary level test, which means that they have to be paid a certain amount, that salary must be a certain amount each given work week, and the current amount is $455 a week. And then lastly is that the employee performs specific kinds of duties that are required for that exemption to apply, and that's commonly known as the duties test. So the executive exemption, as far as the requirements, the primary duty of the executive exemption has to be management of the business or a recognized department of the business. And if there's any time that, when we say primary, that really means they're most important. What are these folks actually doing day in and day out on a daily basis? They also have to supervise at least 2 or more full-time individuals. And then lastly, they have to have the authority to hire and fire individuals, or if they don't have that authority, their recommendations as to discipline, hiring, firing have to be sought, have to be requested, and given some particular weight is what the regulation says, which really means that it's actually seriously considered. It's not just paying lip service, in checking the box on the paperwork. So you think of an example. This could be a store manager in a retail store. It could be a general manager of a restaurant. Those are folks where an executive exemption typically would apply. And again, the last part is the salary base is currently at $455 a week. The next is the administrative exemption, and this one is probably, as you see at the very bottom, it's probably one of the most frequently erroneously applied exemptions as far as the FLSA exemptions are concerned. For the administrative exemption to apply, the primary duty has to be office or non-manual work that's directly related to the management or general business operations of the employer. And that is always a little bit vague as to what exactly that means, but you typically think of something like human resources or benefits or individuals in your accounting department or different people that are performing different tasks that actually help the business itself to operate as a business. And then the next requirement is that they have the authority to exercise discretion and independent judgment with respect to matters of significance. So that could be anything from handling budget issues. It could be that they deal with what type of work is getting done, or dealing with vendors and negotiating contracts, committing the employer in matters of financial that might have some financial significance. If they aren't able to do those sorts of things, if they have to, let's say, follow established guidelines or procedures set out by the employer, then it may be questionable whether they actually have independent discretion and judgment. And again, the last part is the salary level that these individuals have to make, currently the $455 per week. And then the last one, we won't get too much into the professional exemptions, but this kind of notes on what I talked about, the other iterations of the professional exemption. You'll see there's the learned professional, the creative professional, the computer employee, and then the highly compensated individuals that can also apply in many certain instances beyond just the executive and administrative exemptions. So with that background, let's get to what exactly has changed with the DOL's new rules. So effective on December 1st, the minimum salary threshold is increasing from the $455 per week to $913 a week. So essentially is doubling the original salary basis. So I think, don't hold my math right, but I think it's going from the low to mid 20,000s annualized to almost $50,000 a year on an annual basis. And there are, Sam and I have gotten this a number of times, is we've dealt with folks that might have people on the cusp that might make $46,000. And if the exemption applies, it's maybe not that hard of thinking about different raises that would occur along the way. May not impact them as much as it would be the employers that, let's say you might have a store manager that you pay $32,000 a year, and if you want that exemption to continue to apply, you're looking at raising a salary almost $15,000. So, you can see how the doubling of the salary is, at least as far as employers are concerned, is a cause for at least some financial concern in terms of figuring out how they will plan their labor budgets when this 12/1 deadline kicks in. So the requirement still applies for each weekly pay period set by the employer. So you have to make sure that every single week they're making at least the $913 a week, that there's no reason that they would drop below that. And if they were to drop below it, then obviously the exemption is not going to apply. And then as for the highly compensated employee is going from low 100,000s up to 134,000. And then these salary amounts, they have essentially written into the regulations that instead of remaining the flat line, how they have over the past 10 years, every 3 years it's going to be updated, most likely pegged to inflation levels. But there's no set in stone what those numbers will be, and all that the DOL has done is saying, look, when we do make these salary level updates, we'll provide you at least 150 days notice so that you can figure out exactly what you need to do to take note of those changes. Now, when it comes to the salary level, the other thing is changing that's different from now is that the regulations will allow employers, although it doesn't seem like it's a lot, to satisfy just 10% of that salary level through non-discretionary bonuses, incentive payments, or commissions. But again, Sam and I are dealing with someone right now that they pay individuals $25,000 or $30,000 a year, and then these folks are making $75,000, $80,000, $90,000, $100,000 in commissions a year. That if you can only credit 10% of that, then you're left still with a very substantial amount to make up. The other piece on this 10% is that at least folks that I've dealt with is we're really not worrying too much about the 10% right now, not trying to figure out a way to fit some of that salary requirement, how we can build into it this 10%, because the information in the regulations is just, it's very vague right now. There's not good guidance on what's the appropriate way to structure compensation plans as far as that 10% is concerned. So there's a little bit of a holdback on really taking advantage of that right now, just because there's no good guidance on exactly how, if you want to take advantage of the 10%, how to do it. Yes?
So that 10% is based on the 913 threshold?
That's correct. So, and the other question that we get now, okay, these changes are taking place, do these apply? To me, is there any temporary reprieve I get, to comply with these? And generally, no. When that December 1st deadline kicks in, everyone's going to need to be in compliance with it. There's a very limited non-enforcement that the DOL has mentioned, and this involves employers that provide Medicaid-funded services or for individuals with intellectual or developmental disabilities in residential homes and facilities. So they've said, look, we're not going to enforce the $913 salary level to you yet, but come down the road in 2019, we'll start enforcing it then. So giving those employers a little bit more time to figure out what they need to do to comply with those provisions. And then the DOL has also issued some separate materials on the application of the new changes in nonprofit sector with governments and higher education. But generally, for most private sector employers, and even for most public sector employers, the changes are going to take effect on 12/1, and that's really the assumption that unless you fall in the Medicaid-funded services or maybe the nonprofit sector or higher education, that you should start planning for. So this kind of brings us to, great, okay, the changes are taking place, what can I do about it? And I kind of highlighted this at the beginning, what Sam and I are talking to people about and what we've been doing for them. But the first real thing is you just step back to square one and you evaluate the exempt status of all of your employees that you're classifying as exempt. And this could be something that you do, let's say a self-audit, or you bring in a third party to do an independent audit to review the individuals that you've classified as exempt and determine whether you've applied the exemption properly, if not, or to determine whether there's some other exemption out there that could possibly apply to these individuals. And then from there, you use the results of that self-examination or the independent audit to figure out what do you want to do with those individuals. So if you have some that won't qualify for the exemption, we'll be figuring out how can you pay these individuals. There are others that maybe do fit the exemption, but your budget can't handle raising their salary, let's say $20,000 to meet the salary threshold. So it gives you time to figure out, okay, we're not going to classify them as exempt, but how can we pay them that will be consistent with what they're making now? What can we do to place limitations on hours, or what can we do to budget for times where those folks might have to work overtime? And then, the last thing is coming up with, there are a number of alternative pay structures and ways of communicating with the individuals that either are no longer going to be exempt because they don't fit the exemption, or that you don't want to treat as exempt anymore because you don't want to rise their salary level to meet that the threshold. And that's kind of the second piece, is considering the other pay alternatives under the FLSA that it will allow for. And when you're doing, if you're doing this on your own, if you're doing a self-audit, again, things to keep in mind is when you're looking at each individual, you really have to seriously ask yourself, are they really exempt? And remember that these exemptions, again, are going to be strictly interpreted against the employer. There are specific requirements that apply, so you don't want to just pull out a job description or think this is what our competitors are doing, or these guys have just been treated as exempt for the past 30 years, so that's how we're going to do it. You really want to step back, look at them individually, whether that's speaking to them, whether it's speaking to managers, whether it's using questionnaires to ask them what is it that they do day in and day out. So you have a very good, clear picture as to what they're doing, because I always tell this to people, is the focus now is on the salary level, and everyone is very concerned because it is a doubling, but just as important as that is that you can't react to the change by just doubling someone's pay. Just as important, and I always think it's even more important, is what are these folks that are on the ground actually doing day in and day out? And I know it's in there in a I reference it in a later slide, but I always think this is very critical, because I remember a few years ago there was a study, and I know it's not in Ohio, but it was out in New York when I was practicing. There's a place called the Brennan Center for Justice, affiliated with NYU Law School, and they did a study of employers just gauging compliance with employment and labor laws, and found and determined that almost 80% of employers are not in compliance with labor laws or employment laws in one way or another. And the majority of that oftentimes came to compliance with the FLSA, a lot of times with how are you paying people properly, or are you misclassifying folks as exempt or non-exempt when they should be the other. So it's something, I think, in all the talk about the change to the salary level that kind of gets forgotten in that is also just the importance of that. The other part of the test is are these individuals doing the kind of duties for this exemption to apply? And again, remember, the burden is on the employer. So if an employer were to ever challenge it, then you have to prove that, let's say their primary duty was management, or that they had the authority to hire or fire. So you could think of a situation, maybe if you assume that, let's say, an assistant store manager is involved in the hiring process, but if you never took the time to talk to them and they challenge it and said, look, the store manager did all the hiring. I was never involved in hiring. And if you didn't speak to the individual, you're not going to know that they're not performing a duty that's required. So, keep that in your mind, that you do have that burden to prove if it's ever challenged. And again, I mentioned this earlier, that the exemptions relate to an individual specifically, not to job descriptions, not to, a lot of people always think I'm paid a salary, so I'm exempt, or that we always treat these positions, or everyone does it this way. Throw it all out the window, and you really want to look at each individual, because there have been a number of times when I've dealt with folks, same job title, maybe even working in the exact same location, but they're doing entirely different things, and an exemption might apply to one and it may not apply to the other. And if this sort of stuff ever comes up in litigation, which over the past 10 years, it seems like almost any employer is getting hit with wage and hour litigation, over failure to pay overtime, or over misclassification of exempt status. These are things that plaintiffs' attorneys will be digging into, and it becomes even harder for employers to meet that burden in terms of proving that these exemptions actually apply. So I mentioned earlier, if, let's say, an employee is exempt and you just don't want to raise the salary level for them, or if you have someone that is not going to meet the exemption at all, and now you've got to figure out, how do we pay this person, or what are different alternatives? And again, you can kind of go back to what's always been out there, is whether it's paying by the hour. There's also, we've talked to individuals about straight time compensation for at least 40 hours a week, and then obviously there's going to be overtime pay for anything excess of that. There is the pay on the commissions, overtime basis, or a number of other alternatives, let's say a day rate, a job rate, a piece rate, incentive type pay. But these are all different ways that you can structure someone's compensation. And a lot of the conversations we're having is, let's say if someone's making, let's say $35,000 a year, and the employer doesn't want to change that to the $47,000, is there are ways that you can change the compensation structure so that you can still pay someone consistent with what they were making before, which certainly makes that conversation with the individual a little bit easier when you approach them and say, look, there are these new changes out there. This is how we're responding to them. We're changing the pay structure so that we can meet what those new rules are, but you're still going to be compensated in a manner consistent with how you have been in the past. And then the other thing on top of this is, if they're going to non-exempt, you're going to have to be paying overtime pay. And now the rate that you're paying that overtime pay is going to be contingent on how you're paying them. So if you're paying by the hour, it's going to be time and a half. But there might be other times where you're paying them, let's say, a flat rate, and a certain portion of that overtime pay is going to be built in there. So when you restructure it, you also want to look at how that's going to impact what their overtime rate is, so that you can keep that in mind and build that into your plan, so that you make sure when you do change them that they're being paid properly. Any questions so far? And the other thing, I highlighted this at the beginning, but the importance of the accurate timekeeping. Everyone knows for non-exempt employees, you have to keep accurate records of their time. Essentially, any time that they're being required to work has to be captured. And a lot of times you might have a handbook policy that pays lip service to the importance of timekeeping, but it's certainly, with these new changes coming up, is even more important to reinforce. And even there's a lot of litigation out there, and maybe individuals that are involved in some of it or have read about it. Some of it you're talking about 5 to 10 minutes of time that's not being captured, and now all of a sudden you're dealing with, a class and collective action involving thousands of individuals, and you're talking, potentially millions of dollars in liability. So this is just the changes. We tell people it's a good opportunity to be self-critical and look at yourself to make sure that you're in compliance with these different rules, and also, to reinforce the policies that you've had out there that are consistent with the law, but making sure that the folks on the ground are aware of them, that they're following them, that you've updated your training on it, because obviously, let's say if you're changing someone from exempt to non-exempt and you want to have some semblance of control over the hours that they're working, the timekeeping aspect becomes even more critical so that you can monitor the amount of time that they're working if you want to try to limit overtime that might be worked by those folks, so that at the end of their pay period, you're not looking at a timesheet that has you paying them 40, 50 hours of overtime, or just some wild number that you weren't planning for and weren't budgeting for. And I have on the last thing, consider time tracking for exempt employees as well. I always think it's just a very, I suppose from experience, a very important thing to do, especially when it comes now with so much litigation by exempt employees challenging their classification status. The way that this plays out in our world is someone challenges their exempt status, and when it comes to determining an employer's liability to these folks, you have an employer who, remember, has the burden to accurately track all of their employees' time. And you have no records of it, so what the courts do is they'll look to the employee to make a good faith estimate as to the amount of time that they're working. So you might have folks making allegations that they work 45 hours a week, but I've had others where people said they work 85 hours a week, and there's no records on the employer side to rebut that. So the number that the courts ultimately will go with and how plaintiffs' attorneys will value those cases will be based on the estimation of that employee's typical or average work week. So it can be sometimes a hard practice to put into place, and it's certainly not something that's required, but is definitely worth considering doing, just so that, for beyond just the liability aspect, but just so that you know the amount of time that your employees are out there working. And this kind of brings us to the last piece, is why should you really care? Beyond just following the law, beyond making sure that your employees are being compensated appropriately for a fair day's work, as the FLSA set out, but is that just the litigation surrounding these FLSA violations. There's a reason that they call them bet the company litigation, and it's a lot of times because they're 6, 7, 8-year or 8-figure settlements. You have them ranging from hundreds of thousands of dollars to, everyone probably at least heard about the Uber settlement for $750 million. It's not going to go to that amount, but you're talking serious amounts of money, and most employers out there can't afford to take a multi-million-dollar hit because it was not in compliance with the FLSA. And so the reason, the FLSA litigation is very attractive to plaintiffs' attorneys. The biggest reason is it's a remedial statute, so it's what's called a fee-shifting statute, which means that if they are successful at prosecuting an FLSA claim, then they're entitled to recover the attorney's fees for that. So you can see why a multi-million-dollar settlement would be attractive. The cases aren't very expensive to prosecute on that end, but even if it's not a class and collective action, you could have an individual suit that might resolve for, let's say, $5,000 or $10,000, but an employer is still writing a check to the plaintiff's attorneys for $50,000, $60,000, or even more just to cover their fees. So it's kind of a win-win, just knowing that there are not that many of these cases that will ever go to trial. It's 99% of them are going to settle, and they know that. It's just a matter of when and for how much. And the other thing is that the FLSA is not, as much as Sam and I would like to think we're smart, it's not rocket science, but it is a complex statute, and it's not an intuitive statute, and it's very easy to run afoul of just a very small piece of it. And as I mentioned earlier, there was the study that said, something like 3/4 of employers were not in compliance in one way or another. And obviously it's not necessarily that it's inadvertently skirting the law, or an employer looks at it and decides, we're going to take this risk because we'll be better off even if we get sued for it. It's a lot of times employers are really trying to follow the law, and they slip up in a little way, and it ends up costing a lot of money down the road. And the other part is there are other, besides just the monetary, you don't see these all the time, but there's certainly threats out there. You could have potential individual liability, especially under state laws. There are potential criminal penalties, and it can be bad publicity. It can be very distracting for an entire workforce. If you think of, let's say, assistant manager misclassification litigation, you could be potentially talking about 3, 4, depending on the size of the employer, but it might not be that crazy to have 3,000, 4,000 employees, if not more, wrapped up into something, and then that become the talk on the shop floor, as opposed to individuals focusing on making sure that they're being productive in the workplace. And I guess the closing thoughts is, the one I suppose that I would say is it's not, Sam and I don't come in here and talk to people about the FLSA to scare people. It could be one of those things that in some part is a little bit of a blessing in disguise, in that a lot of employers haven't taken the time or may not have taken the time before now to step back and reevaluate their compensation structures or how they've been treating the exemption status of employees, and I've talked to a number of people that have said, we've treated this employee as exempt because HR did that before me and they did it before then, and we've just been doing it this way for 20 years. So it is an opportunity to step back, look at what you're doing, and figure out, are we doing it right? Then great. And if not, what can we do proactively to bring ourselves in compliance with these new rules? You can always tell employees as part of those conversations, you can, we tell people you can blame it on the DOL, or you can say, look, these guys, Sam and Matt, here's their card. If you have a problem, blame it on them. They were the ones that told us that we had to do this, so don't be mad at us, be mad at them. Lastly, I was talking to Marla earlier, it's interesting how sometimes these presentations are very timely. Just yesterday, there were about, I think, 21 states filed suit against the DOL challenging these changes, claiming that they've overstepped their constitutional authority by setting a minimum federal salary level. They also, try to take an argument and say that you're establishing a salary level of almost $50,000 without actually taking a look at the duties that the salary is going to be tied to. And I suppose the implication there is that some folks might not be performing duties that warrant that level of salary, whereas maybe others are. But I think, I would still tell people, even with that challenge, that you still operate under the assumption that the changes are going to take place, and that they're going to take place on December 1st. I would imagine back in 2004, when there were the same changes to the salary level test, I'm sure that there were lawsuits to challenge that, and obviously the changes took place. And I think that's the one thing that's clear. It's been 3 years in the works, and despite the challenge, I think at this point, we tell people to keep forging ahead as though the changes are here to stay. So, any questions? If not, I can turn to Sam. Yes?
Do these rules have to stick with a change of administration, regardless of political party?
Sure.
They
Sure. I mean, that's.
leave them alone?
If they want to change them, they're going to have to go through another, what could be a multi-year process again. So, even they're always, you think the same thing. There are always threats, about repealing the Affordable Care Act or different things. But realistically, it's one thing to say it, but it's a very difficult process to make those changes. And I think that would be the same thing here. So maybe a different administration could make a change, but it's still many years in the making. And until there is a change in the law, this is the current law for now that's on the books.
The employer, as well as the legal community, has a lot of time invested in training.
Right. Sure. Yeah, so, unless a court would tell you you don't have to follow this, then, I think most employers are going to operate under the assumption that the change is going to take place and kind of see what happens if there are other challenges out there. Yes?
So I'm back here reeling, trying to get my head wrapped around this, because I'm trying to figure out, I've listened to everything you said, but I'm still not sure who it actually affects.
Okay. Who these changes will impact. So they're going to impact your workers on the ground that might fit into one of the white collar exemptions. So are you affiliated with an employer, or?
I'm a paralegal at a law
Okay.
firm in Columbus, but I'm actually thinking of my daughter.
Okay.
Not to be rude, but I texted a couple questions to her, and I said to her, do you clock in and out every day? And
Sure.
She said no.
Yeah.
And I said, are you considered exempt or non-exempt? And she said, well, I think I'm considered exempt.
Sure.
And, I asked a couple other questions. Are you paid hourly or are you paid by salary? She wrote back and said, why are you asking me all that?
No, it could very well be that your daughter could fall into these if she's if she is considered an exempt employee, which it sounds like she probably is. If the exemption status that her employer would be claiming for her, if it would be, let's say, the administrative or executive or professional exemption, if one of those are the ones that.
She falls under the professional exemption.
Okay, so right, and so it could potentially impact her to the extent that, as far as the salary level is concerned, as to whether and assuming she meets the duties requirements of it. The easiest example of this would be you walk into a local restaurant or local retail establishment, and you think of a store manager or a restaurant manager or an assistant manager or a team lead or a supervisor. It's going to be that would probably be the biggest example that you might interact with on a day-to-day basis of someone that you can look at and see that it's going to impact them, at least on the salary level. So that's who's going to be impacted, and it is a vast majority of workers. I mean, a lot of people might fall under one of these exemptions, and that's going to be the big question: is how to, if you as an employee that is treated as exempt, if that treatment is appropriate, then if you don't meet the current salary level test, how will your employer handle that, either bringing your salary up to meet that or figuring out a different way of compensating the employee to be consistent with the law?
I would just say an example, Teresa's You know, we represent a lot of industries like hospitality, some in the fast food industry. And each of these industries have a kind of a sense that positions that are vulnerable to this. And yeah, there are a lot of them have been panicked and stressed out about these changes, which is tremendous.
Any other questions?
Thank you, Matt.
Matt and I were kind of talking this morning. He was going to talk about money, and I'm going to talk about sex. So now that we've gotten the money out of the way, let's see if we got this. Well, you know, I hate to, again, Matt and I have been spending a lot of time on the Fair Labor Standards Act lately. And we have been, I think, lecturing on this topic in and out of different industries for almost 18 months. So help us get the word out. There's a big change coming. This is a really big deal. The reason it's a big deal is we deal a lot with the plaintiff's bar. And the plaintiff's bar is, there's a big industry out there that makes a lot of money on the plaintiff side suing employers under the Fair Labor Standards Act, and they're salivating. And they're excited to see what happens in December. You know, I was there when we went from, I think it was $255 to $445 a week as a salary change. What was that, I forget exactly when that was. What was that? 2004, yeah. And I remember the fast food industry claiming that it was going to be catastrophic. They'd never be able to survive. And, you know, they did. This one is also a pretty tough hiccup in terms of change. So I think we'll survive it. It is possible if there's a lot of chaos, there could be a correction depending on the election. But I have never seen anyone reduce the minimum wage or really make major changes in this area once they start, right? Okay. So we're going to talk about another interesting topic that's been in the news lately. And we've actually really enjoyed this. It's like a number of employment issues, this one is highly political and has captured headlines in a number of different states as well as Ohio. And it has been treated differently in different parts of the country. I've been with Fisher and Phillips now for approximately 2 years. And one of the really things that I enjoy about my practice with this firm is that we're so huge. We have offices in California, New York, Texas, all in between, North Carolina. And the attorneys talk and discuss issues that are happening in their area. And there is a lot of difference between the issues that are going on in California, those in Florida, those in North Carolina, Texas, and Ohio, and New York. So change is coming. First of all, my view, and I should give that to you, and it wasn't my intent to lecture a lot in this area, but with our client in the hospitality interest, we started getting a lot of calls in the last couple of years, which had surprised me. May have one issue or two every few years about employees who are transitioning or transgender or sexual orientation issues, but over the last couple of years, we have received a lot of calls. Simply questions like, what do we do with our dress policy for this individual who's transitioning? How do we handle the bathroom issue? This was brought to our attention. How do we deal with that? I'm not sure if there is a increase in the population. I don't think so. I think it's more of a increased awareness of the issues, as well as people willing now to come forward and speak up and try to get attention and address it through the mainstream, right? But my viewpoint of this as a management attorney, and my clients simply want to get the work done. And they want a very practical approach. They want to stay out of litigation. They don't want to make headlines. They want their employees to work efficiently and get the work done. And they definitely don't want to make policy stands that bring them into litigation or, again, make make headlines. So let's take a look at the changes that are occurring. There has been a lot of change. If you look back 10 years ago, I could have told you there was simply not a lot of restrictions on how private employers want to handle issues related to sexual orientation or gender issues. Part of that, again, I think is just the public awareness, particularly with the same-sex marriage issues. The other is, I think, due to medical technology. Now, if you go back to the 70s, there are incidences where individuals would transition from male to female or female to male. But the medical technology to do this is quite amazing, and we'll talk about that now. So I think one is the rapid change in our ability to actually transition individuals from one sex to another. The other is this growing awareness. The other aspect of it is the public sentiment has changed in this area. LGBT issues have rapidly evolved. Although Congress hasn't passed any laws that regulate sexual orientation or gender identity, many of the courts have started to broaden out our current laws to add aspects of that, which we'll talk about. And of course, again, the major change seems like forever ago, but it was back in June, about a year ago, where the Supreme Court legalized same-sex marriage, again in June of 2015. So first of all, let's talk, is there anything really to protect in this area? And I would suggest to you that the statistics are rather surprising. Yes, there is discrimination against the LGBT community and workers. Although it's a small handful of individuals, the statistics indicate that there's a lot of harassment at the workplace. In fact, according to a 2014 study, 90% of transgender employees alleged to have experienced harassment at work. In fact, if you look in the school setting, 1 out of 4 transgender students claim to have been assaulted. And the unemployment rate is extremely high. It's been reported as much as 85% unemployed. So there's a lot of issues on this. In terms of the gay, lesbian, bisexual, 40% have claimed to experience some form of discrimination. Now, of course, these statistics that I'm talking about, they do appear to vary in region. Oddly enough, in some of the regions where you expect more harassment, there's actually less reporting of it, right? In those jurisdictions, and includes some of the jurisdictions, local jurisdictions in Ohio, where they allow complaints for sexual orientation discrimination, the statistics are showing that they're filed equal to the amount of cases for sex and race. So there is something to protect here, and there does appear to be an issue at the workplace. So let's look at some of the key definitions to make sure that we are all on the same page of what we're talking about. When we're talking about sex in this context, often the courts are talking about the biological sex at birth, that is, whether you were born male or female. Gender can be different from that, and that is the internal sense someone has of being either a male or female. Gender identity is referring to the individual's personal concept of oneself as male or female, and this is really their state of mind. And it can, again, be different from the sex at birth. Gender expression is referred to as ways in which individuals express themselves either as masculine or feminine. That's including how they dress, their speech, their mannerisms, etc., etc. Transgender is referring to someone whose gender that they identify with is different from the sex at birth. Side gender is just a reference to someone whose sexual identity matches their sex at birth. Sexual orientation is the status of being gay, straight, or bisexual, or really their sexual preference. And then there's a couple of other terms that have been bounded about. One is recently the term queer, as I understand it, is referring to someone whose sexual expression and identity is not necessarily male or female, or it can switch. A gender incongruence, sometimes referred to as gender identity disorder, is one of the DMS-3 diagnoses for someone whose gender identity is different from their sex at birth. Okay, and it's a disorder that can be treated, and can be treated in part by transitioning. But the bottom line is everybody has a gender at birth, everybody has a gender identity, everybody expresses gender differently, and everybody has a sexual orientation. But these can be different, obviously, between individuals. And we all have, often in our society, expectations of how someone should behave simply because of their sex appearance, right? One other aspect I should point out is the word transition is describing someone who's transitioning from living and working in one's gender to another. And this could include going through medical treatment, and it can also simply adopting that without medical treatment. Now, it is hard to kind of grasp some of these things without dealing with it directly, and even in terms of attorneys who are trying to assist employers on how to manage these issues with their employees. I have found it very helpful just to go see what's actually happening. And in fact, if you're interested in doing that, I would refer you to the work of Jana Marcus. It's a photographer who has created actually a coffee table book that has taken, I think, tasteful photos of individuals who have transitioned either from female to male or male to female. And in looking at that, my takeaway is it's amazing what technology is allowing. In fact, if you look in the middle here, it's Aiden, who's I think 27, who's transitioned from a female to a male. Now, I'll warn you, in some of these photos, they do show some nudity, but it's somewhat tastefully done. But the transformations from female to a male with Aiden, and then if you look down here with Stephen, who is now a police officer in his 50s, transitioning from a female to a male, it's also starting to the point where you wouldn't really be able to tell, at least I haven't been able to tell with some individuals who have gone through the medical treatment, that they were one sex at birth and now they're a sex that is different. And if you think about the controversy that's going on, it's hard for me to imagine that it would be appropriate now to ask Aiden or Stefan to use the women's restroom, right? And so when I think of these issues, or when I'm talking to employers who are asking us questions about how to deal with this, these are kind of the things that I have in the back of my mind. One thing the literature is telling us is not all transgender individuals follow the same pattern. Again, some will seek medical treatment, some will not. But the goal, I think, for all employers, and this is something that it just comes through a consensus of trying to manage your workforce so that the work is done, morale is maintained, and we stay out of the litigation, is simply to treat all employees with dignity and respect, right? And I think that's the best path to addressing all these issues, is listening, attempting to treat with everybody with dignity and respect, and just focusing on getting the work done and what's necessary to comply with the law. So let's look at the legal issues, and it runs the whole gamut from federal statutes and regulations, executive orders from the president, our judicial interpretations really going back to the 70s, most importantly in around late 1980s, agency guidance, and then of course the rapidly changing laws in state and local, right, including Ohio. Well, let's start up with the federal law first, which the major one for us employers, or for my clients, is Title IX. And first of all, I understand everybody is a paralegal here. Is that correct? Sure. Yeah, all right. Does everybody, is anybody here work in dealing with employment issues and disputes? Awesome. All right. Okay. So, Title IX is the major law that prohibits discrimination on a federal level in employment, and it simply prohibits discrimination on the basis of race, sex, national origin. We have other laws that are similar that prohibit discrimination on disability, age, and et cetera, right? If you look at the statute, and this is the Civil Rights Act of 1964, there is obviously no mention of transgender employees or sexual orientation. So the question is, in that statute, when it says no discrimination on the basis of sex or because of sex, what is it meant by sex? Is it meant biological sex, gender? How broad is that? And that's the question that has been talked about up to this date after its passage in 1964. Now, there has been some attempt to change the law to add specific provisions in it that deal with sexual orientation or transgender, and that's the Employment Non-Discrimination Act, referred to as INDA. This was first passed, or passed. It was first introduced into Congress in 1974 and has never been passed. And in fact, it's been reintroduced every year up until recently. And if it was passed, it would simply ban employment discrimination based on sexual orientation and gender identity. And it would apply to civilians and non-religious employers with at least 15 employees, right? But based on the political history where we are now, it doesn't appear that that's ever likely to get passed, at least anytime soon. One is simply the makeup of the House that's very opposed to that. And the other is a recent decision from the Ohio Supreme Court called Hobby Lobby. In the Hobby Lobby case, this was a privately held corporation that opposed the contraceptive regulations under the Affordable Care Act. And the argument was, we're a privately held corporation, and the individuals that operate this corporation for profit are opposed to it for religious reasons. And it went all the way up to the Supreme Court, and the Supreme Court said yes. In fact, there is a First Amendment right under the Constitution for for-profit corporations to not have that law applied to them. Now, it's a very narrow holding, but an unusual holding. It's the first time that a religious exemption has ever been applied to a for-profit corporation. And as a result of that, it appears that the LGBT community and others who have been pushing INDA realize that probably the best thing to do is abandon having that statutory change because of these religious exemptions, but just focus on the current law and broadening out the definition of sex in Title VII particularly. So how has Title VII applied to LGBT employees over the years? Well, again, it's interesting, and I've been recently writing on the issue of the Civil Rights Act of 1964, and if you remember back, or if you've read about it, that was the first time really on a federal level we said we're not going to allow discrimination against individuals because that they're African American or black, right? And in that debate with Lyndon Johnson in 1964, a Virginia senator, under the guise of trying to strengthen the law, said that we also should include in this no discrimination on the basis of sex. Now, it's interesting that I was reading that his intent was to make that law so controversial that it wouldn't get passed in 1964. And instead, actually, it did pass, right? So that's how we got the word because of sex and because of race as a prohibition of taking those issues into consideration in employment. Clearly, Congress back in 1964 could have put in there that we're simply going to bar discrimination against blacks and women. But they didn't. They said we're going to prohibit discrimination based on race and sex. And if you think about it, they've actually adopted kind of this equality idea here, right? It's not just women and blacks, it's anything related to sex or anything related to race. And over the years, the courts have taken that as they should and simply said, well, that means you can't have discriminations of whites and certain rare circumstances, and you can have discrimination against men, right? And other statutes have picked that up, particularly in the colleges and university settings with higher education under Title IX, to say, no discrimination on the basis of sex in education. Okay. But there are two. So, question is, was the use of the word sex limited only to biological sex, or did it mean more? And there are two cases going back to the 80s that have opened that up. The first one is the Price Waterhouse case, very important case in this issue, and that's 1989, right? And in that case, it was a female employee who was denied partnership in a large accounting firm, which is Price Waterhouse. And the reason that they denied her is they felt that she was not feminine enough, right? She was too macho. They alleged that she overcompensated in being a woman. She needed a course in charm school. She was aggressive. They said that she should walk, talk, and dress more femininely, and should be, wear makeup, jewelry, and hairstyle. And in fact, they also argued that she cussed. And when they looked into that, the partner says, well, we don't mind cussing in the workplace, we just don't want women to do it. Right. Well, that didn't go over well. And it went up to the Supreme Court, and the Supreme Court said, well, does sex discrimination prohibit that? And they said, yes, we think it does. And they developed this concept of discrimination not based on your biological sex, but based on your stereotype of your gender, right? That you're a woman, therefore we expect you to behave in a certain way, that is apparently to wear, dress femininely, have a certain hairstyle, and not cuss. And if you are discriminating on the basis of gender stereotyping, that is a prohibited concept under Title VII in employment. That opened the door to where we are today, I believe, right? The other interesting case that kind of moved that ball in terms of the definition of sex in Title VII is the On-Call versus Sundown offshore oil case. Another important case. This was in 1998. And the question was, can you have same-sex harassment that's prohibited under Title VII? Can you have men sexually harassing other men? And again, there was a question in the 70s, too, about whether sexual harassment is a form of sex discrimination, and they solved that problem, too. It's not necessarily about biological sex, and we know sexual harassment isn't necessarily about sexual desire. It's really more about power, right? But going back to this on-call case, this was an oil rig worker who was, and if you read the facts, they're pretty outrageous. He was treated and he was poked and pushed and taunted and a whole series of humiliating actions that are not appropriate to talk about in polite company. And he was also threatened with rape. And the Supreme Court looked at that issue and said, yes, you can have same-sex harassment, whether it's women harassing other women or men harassing other women, if it's about sex and it's severe and pervasive enough to violate the law. And so that also broadened the idea that we're talking in terms of prohibitions in the workplace about discrimination on the basis or because of sex, more than simply the biological sex, right? So that was the opening. And then the EEOC stepped in, and that's the federal agency that's tasked with enforcing employment laws across the country. And they came out with every 3 years, they come out with their strategic enforcement plan that talks about what they're going to do for the next 3 years. In fact, they're about to launch their next one, and we're all excited about seeing what they're going to do because this keeps us very busy, right? But in 2013, actually they released it in 2012, they came out and said, hey, we are going to help expand the coverage against prohibiting discrimination against lesbians, gays, and bisexuals and transgender individuals under Title VII. And we're going to encourage and develop those issues. And they have, and they do allow individuals to file charges of discrimination on the basis of sexual orientation. Now, the federal courts haven't bought into this. Most federal courts today take the position that sexual orientation discrimination is not sex discrimination, and either address it under the issue of this really related to biological sex, or it's just simply not in that statute. But that may be changing, but it's not yet. The majority of federal courts do not recognize sexual orientation discrimination to be part of Title VII. Okay. But that hasn't stopped the EEOC from going after employers. And in terms of transgender employees, yes, ma'am.
I was just going to say, we have EOC person.
Oh.
Who made some comment on it.
Okay, so don't sue my clients for anything I've said.
I am not from the EEOC. I'm with the Ohio Department of Transportation, but I am an EEO investigator now and focusing on Title VI, Title VII, issues ADA, age discrimination, things like that. So yeah, I have a personal interest, not in transgender issues, but certainly in sexual orientation issues. So I really don't have anything to add at this point, but
Well, so this is the federal agenda. Yeah, you know, I started out in Columbus as an assistant attorney general in Ohio in the employment law section. Back then it was called the federal litigation section, and our task was to protect the state employers in all these issues. And we had another section that pursued employers who violated the Ohio law, called similarly the employee, I think it was called the Employee Civil Rights section in 1990, blah, blah, blah. But yeah, so there's a lot of interesting issues, and you know, I think to be a good lawyer, whether you are pursuing employers or protecting them, you need to understand the both sides, truthfully. But look at what the EEOC has been doing actively with regards to the LGBT community, including transgender. You know, in 2011, they have basically said, you know, really, when you're dealing with discrimination against individuals because of sexual orientation, a lot of that discrimination is focused on the fact that the individual is not behaving pursuant to the expectations of those around them as to their gender. And that's a form of gender stereotyping back to the Price Waterhouse case. Therefore, you know, we're going to pursue that, and they did in 2011. And in 2012, now again, sexual orientation and transgender is different, right? One's sexual orientation is about someone's sexual preference. Transgender is someone who has changed their gender, and they may not have changed their sexual preference, right? And I think you can make the argument that transgender issues are more about gender issues. I think that's probably fair to say. But there's more to that as well. But in 2012, the EEOC has come out and clarified that we think that any discrimination against individuals who are based on their transgender status is sex discrimination under Title VII. You know, in 2014, they filed their first 2 lawsuits directly against employers on transgender discrimination. And then, you know, they've been struggling with the federal courts as to whether sexual orientation should apply to this under Title VII. And in 2015, in the Fox case, they basically said enough of this. We're just going to take the position any discrimination on sexual orientation is discrimination under Title VII. So they are bringing in the entire LGBT community under Title VII. Now, have the courts, federal courts, adopted that? No, they have not, particularly with under in sexual orientation. But the courts seem to be adopting the expansive view of rights for transgender employees under the idea of gender identity. Okay, does that make sense? Now let's look at Ohio law now too, and how that's being applied. Our main Ohio law is Ohio Revised Code 4112.02, which you'll be dealing with. And it, again, does not have any mention of sexual orientation or transgender. It simply prohibits discrimination on the basis of sex and other things, race, sex, age, national origin, disability. And our Ohio courts also do not interpret that law to include issues of sexual orientation or even transgender status. But we have a lot of local laws that have been passed that have incorporated in that, right? In fact, Columbus makes it a crime to discriminate on the basis of sexual sexual orientation. And there's I've had to actually pull out the map from some cases to determine whether we're in Columbus or outside of Columbus. But there's been a whole host. Yes, ma'am?
For the most part in Columbus, can't you still be fired for your sexual orientation in some places? Or?
Not in Ohio, not in Columbus. It's a crime to discriminate against individuals in the city of Columbus. And in fact, federal Judge Marbley has argued that in city jurisdictions or local jurisdictions where it is prohibited, it could also be the basis of what's called a Ohio public policy tort. So I would, first of all, we don't recommend you discriminate against your employees on any basis. And the only reason we're pulling this out is just to figure out what the strategy is, the legal arguments. But the best thing to do is just at this point really consider it as part of the landscape, as something not to do.
But on a federal level?
Yeah, even on the federal level, because the bottom line for our advice to employers is we want work done. We want to treat employees with dignity and respect. Unless there's a very unusual issue, we don't care. Let's get the work done. Let's not discriminate against anybody on any basis, religion, on sexual orientation, transgender status. If there's a problem, let's solve it. That's the best thing. And if a lot of our clients are multi-state and they've got footprints in different states, and if they're operating in California and Ohio, then really they don't want to have multiple patchwork policies. A lot of my clients have in their own EEOC statements that we are not going to discriminate against individuals based on race, sex, age, national origin, religion, disability, and sexual orientation, right? And I have a feeling a lot of us who are employed also would have that in their policies. But if you look at the laundry list of cities that have these, everywhere from Cincinnati, Columbus, Canton to Yellow Springs, which is not surprising for Yellow Springs. Yeah, right? And this is changing. I mean, this list, every time I write it, there's a new, to put on there. I haven't seen any in Ohio that's done the opposite, but so it's growing, and across the country it's growing. So what are our legal obligations to transgender employees? Let me see how I'm doing on time. Well, we've had a lot of publicity lately, and some of these slides I've created several months ago, and they're starting to get old. But we have Caitlyn Jenner, who's made a very public debut recently. She's not although she's one of the more recent ones, she's not the most recent celebrity. In fact, I've got news articles going back to the 70s, everywhere from judges to tennis players, right, that have come out as transitioned and transgender. The population, though, appears to be small, right? The statistics suggest that it's about 700,000 employees. And so there is an argument, I think is correct, that is a lot of these issues are really disputes that are really a non-problem and more media hype than an issue. I do couch that with the fact that we have been getting calls a lot, though, from employers about, hey, we've got this issue. But, good news is that a lot of times it's very simple to resolve. Typical question, got an employee who say they're transitioning, they would like to use the grooming policies that we have for women as opposed to men. And, the typical response is, fine, tell them to pick one and stick to it, right? Problem solved. We are seeing a little bit of uptick in litigation. Again, as we've indicated, Department of Justice has taken the position that Title VII protects transgender employees. I think they may be correct in terms of the evolving definition of sex. Oddly enough, in a surprise direction, OSHA, and we'll talk a little bit more about that, has announced that it is a workplace safety issue not to provide restroom use for the gender identity of your employees and have issued a guideline for restroom access for transgender workers, right? So there are three typical issues in these litigations that we're dealing with. One is restrooms. Everybody's talking about restrooms. Second is dress code. The third that we don't see a lot of publicity on, but is also pretty prevalent, is what happens when our customers or coworkers have bias regarding individuals who are identified as transgender in the workplace. Again, our position is that, if you are an employer that are having to deal with these issues, some of our clients, and I think a couple in this room, actually have unisex restrooms or dedicated restrooms. Particularly, that's a growing trend because of the lactation rules that require you to provide lactating employees with special rooms, right, that are not restrooms. So there's a lot more options, I think, that some employers have now that they have in the past. But one thing that is just a bad idea is to limit an individual's restroom use based on their sex on their driver's license. That's just not working in litigation these days. In fact, when those issues are disputed, we're just not seeing anyone winning, including in the education field. Dress code, about what code should apply. Typically, you want it to apply to their gender identity and not force it again based on biological sex. Those aren't winning. And then in perceived customer bias, the general view is whether you have employees who are African American or women and they're biased by those attributes. The same concepts apply to sexual orientation and transgender status, right? The courts aren't caring that your customers are upset about it, right? So you're just going to have to address it. In terms of restroom issues, there's a lot of different local and federal laws that we can point to. I mean, one of the more interesting is Utah was one of the first states that actually required employers to provide reasonable accommodations to employees based on their gender identity. Massachusetts just did that in July of 2016. In 2015, the EEOC ruled that U.S. Army discriminated against a transgender woman for refusing to allow her to use women's restroom, and have pushed out on that. And then again, as I've indicated, OSHA has come out, indicated it's actually a workplace safety issue if you do not allow employees to use the restrooms of their gender identity. Let me focus a little bit on OSHA for a second. OSHA, and it's a 3-page policy, and if you email me, I'd be happy to send you their guide to restroom access. And it's not overly complicated. What they're saying is that if you do not allow individuals to use restroom based on their gender identity, they do not use the restroom. And not using the restroom causes severe health concerns. And it seems obvious, but apparently it's true. And as a result of that, they say if you don't allow it, that violates our general duty clause that all employers must keep a safe workplace. And they indicate in there that if employers aren't doing that, they may invoke their power to enforce the general duty clause under, again, this workplace safety issue. There have been a host of other attempts to address this. Some have been trying to put the genie back into the bottle and focus restroom use only on sex at birth. Some have gone the opposite way. Here's Mississippi and North Carolina. North Carolina, right? They've been in the news a lot. We've been focusing on it because we deal with the hospitality industry that is very upset about it. As you know, North Carolina passed a statewide law that requires individuals to use restroom based on their biological sex. And again, if you think back on those two individuals in the sheriff and or the police officer and who have actually medically transitioned it just doesn't make a lot of sense that you would have them, who appear to be very clearly males, walk into a woman's restroom, and I think the reaction on that. So as a result of that, a lot of entities have pulled out from booking concerts to hotel reservations are down in that state. The NCAA has canceled its right, and there's another one, I guess the most stinging of all is that they have a lot of these high school and sporting championships, and they have just the other day pulled out as well, which is really bitter to North Carolinians. As a result, I have a feeling that with that pressure, things may change, but we won't know, right? But that's one attempt to go the other way. I mean, there's just a whole host of Arizona, Massachusetts. Here's Massachusetts. They actually passed it, and it went into law in July of 2016, and it permits individuals to use the bathroom of choice, or they're based on their gender identity, and all sorts of gradations in between. Another thing that we have been dealing with that crosses into the employment is Title IX. This is the federal law that prohibits discrimination. It was intended to prevent discrimination against women in educational settings, but it's very broad. It also applies to employment in educational settings, and it doesn't say women. It says no discrimination in educational setting based on the basis of sex. And as a result of that and the expanding definition of sex, the Department of Education, in conjunction with the Department of Justice, came out with what they call a Dear Colleague letter to all colleges and universities who were receiving federal funds that they must allow access to restrooms of the gender identity of their students. And they go beyond that. Also housing based on the gender identity of their students, and locker rooms and showers, and participation in sports, and pronoun usage of the students. It's a very broad law and interpretation. And of course, there's been a lot of litigation from certain attorney generals, including the state of Ohio, to push back on that. We'll see how that plays out. So what do we do? What's the takeaways? Well, first of all, if you are representing an employer or have an issue in this area, you want to check your local laws and regulations, because they may be very different. And I can promise you, if you're in North Carolina, you're going to be treated differently than if you are in Massachusetts right now, right? It's our advice generally to our employers, don't mandate restroom use. Just stay out of that area. Most of these issues, no one's really bothering anybody. Once in a while, someone will come to you and say, hey, this individual's in the restroom and that's bothering me. That's when you sit them down, figure out what's happening, investigate it, take appropriate action that's reasonable based on this, and that usually solves the problem, right? By the way, one of the laws, in 1990, the Americans with Disabilities Act came out. It's one of our major laws that prohibits discrimination on the basis of disability and requires to do, 1, no discrimination, and 2, you must provide reasonable accommodations to people with disabilities. In that law, Congress put in there that it accepts transgender status. So the ADA doesn't apply. State laws, though, may, but the ADA does not. Just point that out. But if you can, you want to accommodate, and when I say accommodate, I mean help work with the employee to work out the issue of using a bathroom of their gender identity. We do that with our employers all the time, and it's not hard to do. If you have other private facilities, you can suggest that. Some of our hotel clients have a lot of different bathrooms they can use. And if you have the unisex gender neutral facilities available, use that as well, right? In terms of issues about dressing the part, we've had a lot of interesting litigation. Typically, you hire an employee, that employee comes to you and says, look, I'm transitioning, I'm now becoming a transgender male. We've had litigation about terminating employees for that. We've had a Florida eye clinic that terminated an employee who transitioned from a male to female. And we've had a case in Michigan involving a funeral home where another employee transitioned. Well, here's what the bottom line is to expedite it. We found that if they fire you because you're transitioning, they lose. And some of the verdicts and settlements are expensive. They're just not winning these, right? What we suggest to deal with dressing the part, if you have professional, in fact, there's nothing that prohibits an employer from having professional dress code. In fact, in most industries, you should have one. If they relate to differences between men and female, well, just have your employees pick the one that's appropriate for them and stick to it. In fact, a lot of these issues, the only real trouble that the only real problems that the employees are having when they're transitioning is when they won't stick to one or the other, right? And that is, legitimately, I think, a burden to employers, where you have an employee that uses all the restrooms, or they have they're using different dress codes, and that can be disruptive. And in those situations, we're finding that the employers are successful in defending against that type of disruption. But there's a lot of nuances within that. All right, so bottom line is focus on safety in your policies for dressing the part. Make sure that your policies simply focus on being professional, your public image and productivity. I wouldn't recommend at this point, unless you are in certain states, to require your employees to dress based on their gender at birth, but instead allow them to base it on gender identity. Here's let's see if this is sinking in. All right. First of all, if you have a male employee that tells you he's transitioning from a male to a female, the question is, can you request medical documentation or proof? Anybody? What do you think? The answer is no. The courts are suggesting that you don't do that. First of all, some individuals will transition and they'll actually go through the medical process. I understand it takes about a year. It involves hormones, can involve surgery, and can be quite extensive. Some individuals will transition and they will not follow through the medical, and it would be prohibited generally from you to ask for medical documentation. All right, second, with this individual who's transitioning to a female, can you require that employee to continue to use the male restroom? Yeah, generally the answer is no. You should allow them to use the facility that's consistent with their gender identity. And for those employers that are opposing that, we're not seeing that they're successful. And those schools that are opposing that, they're just not winning those cases. Can you require the employee to comply with your gender-specific dress code or grooming policies? Yeah, the answer is yes, if it's consistent with their new gender identity. What if your coworkers are reacting very negatively to this, or they're hostile, or they're teasing or harassing the individuals? What should you do? Yeah. Well, what we found that's helpful, if you feel that, and it depends on your industry. If you're a longshoreman and you're dealing with dock works, that's one thing. If you're in the hospitality, that may be different. But we found that just having a meeting after talking to the employee about that, explaining what's going to happen, explaining the employer's policy, that there's support for allowing that to occur, and that everybody wants to get the work done, usually we find that solves the problem. Almost all the time. All right? What if the individual is transitioning and the customers complain about it or the clients claim about it? Right? That is a tough issue for some employers, particularly in some of these cases where it's a small employer, it's an eye clinic or a mortuary, and the individual that's dealing with the public is transitioning, and there is a reaction to it. Again, there was this reaction during the Civil Rights Act of 1964 with men and women in certain positions. Women in certain positions, and with individuals of different races in certain positions. The courts are not supporting employers on taking that stand. In fact, it's something that you want to address with your customers. Yes, ma'am.
I would assume that with both coworkers and customers, you would keep that conversation as generic as possible, because if you have someone transition and actually have medical process involved, then you've got the HIPAA protected issue, so you would keep that pretty general.
Well, again, HIPAA may come into play if the individual is going through medical, right? And so that what I mean is you don't want to talk about to the employees about their medical treatment at all. But if we've had some hotel clients who have had individuals who have been dealing with the public or their guests and have gone through a transition. And, usually you can address the customer issues, but with individual issues. But we haven't seen a really need to do much. And those employers that kind of react to that, I think, are overreacting. Some of it's political. So we're not really seeing that much of an issue in the industries that we're dealing with. It can in certain, there are certain industries it can become a safety issue, especially if you're operating a bar or a bowling alley. That can be a concern. But generally, discrimination, whether it's from the employer or from the customers or the population in general, is not a cause to do it yourself. Does that make sense? So what are our best practices? Again, be aware of and comply with your local laws. Ensure that your hiring and employment decisions are based solely on merit, not discrimination. Also, a growing trend, particularly in other countries, but not in the United States yet, perhaps except Pennsylvania, is the being aware of workplace bullying, which is more than just discrimination. It's where simply individuals are picking on each other for a whole host of reasons, which is also very disruptive to workplace. But be aware of that, because that often is associated with issues and disputes involving transgender employees, and do not require medical documentation or proof when an employee brings this issue to your attention. Right. Make sure that your policies are complying with all your local laws. Make sure you train your employees on those policies, and where possible, accommodate. The typical thing that we advise HR is with everything is you're in this constant campaign of reviewing the law, which seems to be changing every month now, revising your policies to reflect that law, training all your employees on what your policies are, then enforcing those policies, then taking a deep breath and doing it all again every year, right? And we've been doing that with you every year. This is another one. We've asked our clients who've had these issues or are in industries where they're more likely to occur to review their policies on grooming, review their policies if they have any on restroom use, revise them, train on them, enforce, and then repeat. The other thing that we found is just a best practice is if you have an employee that comes to you that says, I'm transitioning, the best thing to do is talk to them about it. And based on the circumstances, aware of HIPAA, you may wish to discuss it with the employees that are surrounding that employee, the other employees surrounding that employee, so that there's an understanding that management is in support. And when we see that happen, usually there's not a problem. All right? Really, particularly management support. I was going to talk a little bit about issues on same-sex marriage. I mean, we can walk through that history real quick, and maybe we should. I think we can do it quickly. First of all, there were 3 cases or 3 changes that occurred that led us to same-sex marriage. First was the U.S. versus Windsor, which was a game changer back in 2013. And that was the Supreme Court case that struck down the Defense of Marriage Act. It almost seems like old news, but it wasn't that long ago. If you remember, there was a law that was passed that simply excluded from the definition of marriage same-sex spouses. The Supreme Court indicated that that's unconstitutional under equal protection and due process clauses, and threw it out. Shortly thereafter, in our world of HR, the federal government issued new family medical leave rules that applied to same-sex couples so that they would also have similar protections to married couples, right? For taking care of seriously ill spouses and spouses related to military deployment. And then in the big case, which was the Obergefell, which is 2015, almost a year ago, it seems forever, Supreme Court came out and simply said that we are going to prohibit laws that do not allow same-sex marriage. Major change, right? And so it has lifted state law bans on same-sex marriage across the country and allows states to recognize same-sex marriages. It's interesting, for those employers that were kind of progressive, they were creating a lot of domestic partner medical coverages, right? And once this law came out, a lot of our clients were like, okay, that's all gone. To the shock of all those who were benefiting from domestic partner policies, right? And they say, well, if you want that, you have to get married. And a lot of employees found out that their partner did not want to go that step to keep that health insurance. So the definition of spouse wasn't the individual of a different gender, but it is basically now a spouse is whoever you're married to, right? And again, the changes on this seem a little dated now, but they're everything from tax consequences to broadening of who is applicable for family medical leave, and a lot of impact on health and welfare and retirement plans. And with that, I'll answer any questions. We haven't driven that into the ground. Any other questions? Great. Thank you.